As we embrace this important step, it's essential to recognize how the Child Justice Act works hand in hand with the Fiji Child Care and Protection Bill. Together, these two pieces of legislation create a comprehensive framework designed to protect and nurture our children, ensuring they receive the support and protection they deserve, and that they go on to thrive as adults who will make a difference in our country. The Child Care and Protection Bill, of course, sets a foundation for the rights and welfare of children across our nation, and we will be discussing that next. But by raising the age of criminal responsibility and focusing on diversion, the Child Justice Bill complements the protection of children by ensuring that children who find themselves in conflict with the law are heard and the circumstances that led their offending in the first place are addressed. These laws collectively signify our understanding that children are not simply individuals who have made big mistakes. They are most often children who have survived or suffered neglect or abuse. The Child Justice Bill recognizes that many children enter the justice system due to circumstances beyond their control, and it is our duty to intervene positively. To my fellow parliamentarians, this is a call to action. We must champion the integration of these two acts in our policies and practices. It isn't enough to pass legislation. We must ensure that our systems work together seamlessly. This means collaborating across ministries, engaging our communities, and investing in resources necessary to implement these changes effectively. To my own ministerial colleagues, the success of this legislation hinges on our collective commitment to its implementation. We realize that the passage of this act is only the beginning of our work, but each ministry will have to do their work in bringing the act to life. Of course, our ministry will play a key role in supporting our colleagues, but we will play a leading role in diversion and working with children and their families to understand why those children have come into contact with the law in the first place. As I said when I introduced the bill, many children who find themselves in conflict with the law come from backgrounds where they are homeless, broken homes, or have been neglected or abused. These are the very children we need to protect and support to build attachment with their own communities. To my ministerial colleagues, the Honourable Prime Minister and Honourable Turanga, in Police and Justice, I pledge to support your ministries in the policy and cultural changes demanded by this new law. For the police, this means officers need to be confident and adept at safely engaging with children, to properly understand their circumstances, and to engage with my own staff in offering diversion. It means you will need policies, procedures, and training to underpin this. To the Honourable Minister for Justice, your role is in training legal professionals and law enforcement on the principles that this new act is vital. We must ensure that everyone involved understands the importance of rehabilitation over punishment and is equipped to implement these changes effectively. But this isn't just an act that has implications for the police or justice ministries. Schools are the optimal place to foster environments where children feel safe, supported, and empowered to succeed. The safety will sometimes be the only protective factor for a child where they do not feel this belonging or safety at home. School can be the ultimate circuit breaker to a child coming into conflict with the law through the very provision of this safety and support. I look forward to working with the Honourable Minister for Education.
This bill promotes rehabilitation and reintegration into society. It embodies the belief that every child deserves a second chance, an opportunity to learn from their mistakes and become productive, law-abiding citizens. Mr. Speaker, sir, it is heartening to see that the Child Justice Bill 2024 continues to uphold key protections for children that were previously addressed in the MIDA Act. It is good to see that the following provisions which were in the repealed MIDA Act are now included in this bill. First one is protection of children. The best interest of the child are prioritized. The children are protected from harm. This includes ensuring that children in police custody are treated with care and respect, taking into account their age, gender, and social needs. Number two, content restrictions. This bill prohibits the publication of information that identifies children involved in legal proceedings. This crucial measure protects the privacy and dignity of our young ones, preventing potential harm from public exposure. Number three, privacy. The confidentiality of records related to children in conflict with this law is maintained.
Mr. Speaker, sir, I'm very grateful in terms of the diversion. Madam Minister, you can count on me. There has been some discussion this year with Australia and New Zealand, and next year the Ministry is going to undertake a tour to New Zealand. As we are, Mr. Speaker, sir, you're fully aware of how the Maori community and the New Zealand government have treated this issue in terms of the unique problems facing the Maori and how they deal with it. Our prisons are full of itoke. They start off as young offenders, juvenile, and migrate to become common criminal. The problem in our justice system is that we have not created sufficient diversion. We have left out what we have, our cultural tradition, how to change a man, how to change a woman. And it's about time. And I think with this coalition government, we are committed to do that, Mr. Speaker, sir.